Good morning, everyone. My name is Denise McCarthy from Cody and McCarthy. Thank you for joining us on what is the third segment of our summer education series. And if you just, I don't know if you guys hear it on your end, but I did just hit record. We've had a lot of people that just couldn't make this time slot and have asked us to record the video, but you're not being recorded. So you don't pop up on the screen at all. So don't worry about whether your video camera is on or anything like that. Attorney Shawnee Collymore is here with me today. Today's topic is serving as a power of attorney, which is something we get a lot of questions about because it's a core component to almost every estate plan that we do. And when people face disability or cognitive issues, your power of attorney steps in to take over managing your assets. And we find in practice that everyone has kind of different degrees of how serious they view this role. And ours is very serious because it's a fiduciary role. But I think what happens is, folks are helping their parents or their loved ones already in kind of an informal capacity, maybe picking up groceries or something like that. And then it kind of just evolves into this more formal relationship. You go see the attorney, you set up your power of attorney and formally put this person in the role. But there isn't always that mental switch for the person serving as power of attorney into this more formalized role. And that's what the purpose of today is to try to get everybody to appreciate what is involved with being a power of attorney and how, if you've been named or you have this document, you've named someone, how it should be thought of and viewed. And I'm going to share my screen so that we can see the slides. Oh, and I think, Shawnee, is that right now? Can you see the slides?
Yeah, that's good. Yep.
Okay, good. That's fine. Sorry, third one in and I still haven't quite figured it out, but anyway, so Shawnee's gonna kick things off this morning, and Shawnee, just let me know when you need me to change slides, but she's gonna walk you through kind of what is a power of attorney and get us all to better understand that role in the estate plan.
Okay, good morning, everyone. Like Denise said, thank you for joining us today. So power of attorney is one of the most important documents that you should have in your estate plan before anything else. I do feel that it's the document that at some point we'll all need in our estate plans in our lives. And basically what it is it's a written authorization for one person to act on behalf of another. And generally you're acting from a financial capacity. So you're giving another person to have the ability to do whatever you can do. So sell your house, write checks on your bank account, change beneficiaries on a life insurance policy, whatever the document authorizes, that is what powers you are giving to the person in the document. So that's important to know. However, it is a fiduciary relationship. And what that means is that the person that you're naming as your power of attorney agent has a fiduciary duty which is a legal duty to act solely in your best interest. So they're not supposed to do things that's for their benefit. They're supposed to use the power of attorney to act for your benefit, for what's in the best interest for you. So that's important to keep in mind. Do you want to switch slides? Okay. So this is just kind of a funny slide, and I think it just shows how powerful the power of attorney document is. But he says, "I'm raising my allowance is fine, Dad, but what I really after is power of attorney." And it's kind of funny because he wants power of attorney for the dad, because then the son doesn't need an allowance. He can just do whatever he wants with dad's money, basically. So it's important to keep in mind when you're thinking of who you want to name as your power of attorney agents in the document, that generally, as soon as you sign the document with me in the office, it's effective. And that's really important to remember, because you're giving somebody control over your assets. And it's a lot of power to give to somebody. So you want to make sure that the person that you're naming is trustworthy. Okay, so there's different kinds of powers of attorney. There's a springing power of attorney, and there's durable powers of attorney. Generally, the powers of attorney that you're going to do with us is called a durable power of attorney. It's durable because it survives you ever becoming incapacitated, meaning you sign the power of attorney with me now while you're healthy and doing well. When you really, even though when you sign it with me, it's effective right away, you're really not going to be needing the named person to act unless you're incapacitated. Say you get dementia, something like that. That's when you really need your power of attorney agent to step in and help you. So the durable part just means that it's going to survive you losing incapacity, because that's when you really need it. Generally, the powers of attorney we do are effective immediately. A springing power of attorney is only effective when you become incapacitated. So it springs in and out of effectiveness, basically. I generally don't like to do springing powers of attorney. In theory, it's a good idea, but in practice, it can be a little bit of a pain, because then your durable power of attorney agent has to prove that you're incapacitated every single time they want to use the power of attorney. So that means like taking you to the doctor, getting a doctor's letter, and having that to show to the bank to say, oh, my dad's incapacitated. Look, he went to the doctor yesterday and it says that. But for something like dementia, I mean, especially in the early stages, capacity can like swing in and out so frequently. It's like, it can be really hard to utilize a springing power of attorney. And I know that a lot of banks don't even like to take them for these reasons.
Yeah, and most of our clients, sorry to interrupt, are coming to us to set up an estate plan to simplify their life in the time of a crisis when you do need to use power of attorney. So I agree with Shawnee. We really don't favor the springing powers of attorney, but it is important that if you're named in a document to understand whether it is springing or it's durable. So it's durable, you have the power to act always, really, unless it's turned off at some point. But if it's springing, you'd have to really understand within the document what the mechanism is for proving that that person is incapacitated, because that's what triggers your ability to be able to take any action at all. And that, like Shawnee said, could be a real hurdle and prevent it from being a very useful document.
Yeah. So I don't recommend them. But anyway. So that's springing versus durable. And then there's limited powers of attorney versus a broad power of attorney. The durable power of attorneys that we would do for you here is going to be more of a broad power of attorney. We try to keep the document very extensive, to think of all sorts of scenarios that might come up over the years that your agent might need to act on. Some of the powers in the document you might not need, but you just never know over a long period of time, like what sort of situation will arise. So we try to give you as many powers as possible. A limited power of attorney, a lot of you have probably used this before. An example of this would be like if you were purchasing or selling a home before and you gave your real estate attorney power of attorney to sign closing documents on your behalf. That would be an example of a limited power of attorney. And I bet a lot of you have done this before, where the document would specifically say that your attorney had the power to sign a closing disclosure for X sale price on this property. And it limits what the power of attorney can do to just selling your house for X dollars and signing those documents. That would be an example of a limited power of attorney. And that's a common use for that type of document, is like for selling your house or something. A temporary power of attorney is also the real estate example would be an example of really a temporary one. Temporary meaning that it's going to end at a specific event or time. The powers of attorney, the durable power of attorney we would do is not temporary. It is effective until you either revoke it in writing or until you die, because powers of attorney are only effective while you're alive. As soon as you die, the power of attorney ceases to be in effect because you're no longer alive. So that's generally when your power of attorney would end. Okay. So certain actions that your power of attorney can take. The goal of the power of attorney is generally to avoid court intervention, such as a conservatorship. A conservator is when, if you don't have a power of attorney and you became incapacitated, the only option for your family is to go to court and seek the court to give them authority to act on your behalf. And that's called a conservatorship. You generally don't want to have to do this just because anytime that you have to go to court for something, it's time consuming and it's expensive. And depending on what the circumstances is surrounding you being incapacitated, it could be an emergency situation. Maybe you're trying to qualify for mass health, for nursing home benefits, and it's just like another thing that you don't want to have to deal with. So, proper advanced planning, getting a durable power of attorney now while you're still healthy and able to act and, name people that you want is really important. It will save your family a lot of time and money in the future. As I sort of mentioned before, we do try to have an exhaustive list of powers in the document to cover any situation that might come up. In Massachusetts, your power of attorney has to state the exact power within the document if you want your agent to be able to do that thing. So if you want them to be able to change the beneficiary on your life insurance, it should say that. If you want them to be able to sell your house, it needs to say that. So we're not always able to look in our crystal ball and figure out what situations are going to arise for you. So we try to keep the document extremely extensive and to think of all sorts of powers that you might possibly need in the future and put that in there. So that way you're not, 5 years in, you get dementia and then, you're not able to sell your house or something. So we try to keep it very broad. So it's important, a lot of times clients will ask, oh, well, can't I just print one off the internet? Or their doctor, sometimes hospitals will give you a power of attorney and it's 2 pages long. I mean, that's not really the power of attorney that you want to have. So I think it's best always to seek the advice of a qualified estate planning attorney and get a doc. They're not very expensive, so it's just worth coming in and getting one done properly. Yeah, you can switch slides. So power of attorney versus healthcare proxy. So a power of attorney deals with appointing somebody to make financial decisions on your behalf. A healthcare proxy is appointing somebody to make medical decisions on your behalf. And the healthcare proxy person is generally only appointed when you're incapacitated, only effective when you're incapacitated. So a power of attorney agent is not the same as the healthcare proxy. It's a totally different person and totally different document. So your power of attorney agent cannot make healthcare decisions for you using your durable power of attorney. Sometimes within the durable power of attorney document, it will have HIPAA authorization information in there. So basically granting your power of attorney agent the ability to get medical information about you, talk to your doctors and stuff for informational purposes, but not allowed to make medical decisions. So you can just, yeah.
I just want to add one thing, and because one reason for that, because I think sometimes we think of powers of attorney as only managing financial assets, but because they're really everything but making healthcare decisions, it could include things like filing a lawsuit on your behalf if, say, the reason you're incapacitated is because there's some awful accident. So that's one of the reasons why you'll see the power of attorney is able to access medical information, because they might need to compile that as part of this lawsuit, in case you're wondering why that power is included.
Yeah. And it could also, if they know what's going on with your you health-wise, it could help them make decisions about how
Right.
to spend your assets. If you're doing like a Medicaid application, it could come up in so many scenarios if they're trying to help take care of you. So you can decide to pick the same person to be your healthcare proxy and your power of attorney, but those are still two different documents that you need to sign and have. Okay, so you can switch slides.
Sorry, I forgot I was in charge of the slide.
Okay, powers of attorney and revocable trusts. So generally, assets that are owned by a trust are controlled and managed by a trustee of the trust for the benefit of whoever the beneficiaries are. The revocable trust and power of attorney document each must grant authority to revise the revocable trust using a power of attorney if that is desired. So within the power of attorney document, it might grant your power of attorney agent the ability to create a trust. It might grant you the ability to amend a trust. All of that has to be granted in the power of attorney document and vice versa. If you have a trust and you want your power of attorney agent to be able to act under it, you need to state that so it's clear that that person has the power, that's the intent there. Generally, the assets in the trust are going to be controlled by the trustee. Anything that you have not in the trust, like retirement accounts or assets that you just haven't yet transferred to the trust during your life, is generally going to be the assets that your power of attorney is going to be managing, and your trustee would be managing the assets in the trust. So that could be the same person or separate people working together. So it's not automatic that the power of attorney person is going to start controlling your trust. Typically, if you did become incapacitated and had a revocable trust, probably whoever you named as the successor trustee is going to step in and start managing the trust assets. And it's not necessarily going to be whoever you named as the power of attorney document, but they can kind of work together. But it's not like, but you definitely have to provide for that within the document. Another thing to think about is self-dealing and gifting within the power of attorney. Generally, self-dealing is disallowed, but some powers of attorney do allow for self-dealing. You need to read the document to see if that's in there. There are situations where you might want your power of attorney agent to be able to self-deal. Self-dealing is when your power of attorney agent does something for their benefit. And situations where you might want this would be like if you're married and you're granting the power to your spouse, you might want your spouse to be able to do stuff for their benefit. That might make sense, especially like if you're trying to apply for long-term care benefits through Medicaid. You might need this, but it's something that you definitely want to think about and consider based on who you're naming as your power of attorney agent. You might not necessarily always want that power within the document. So I think could be fact specific on whether it makes sense, but there are definitely times where it's needed and other times where it's might not be a good idea. So another common provision in a power of attorney is gifting. A lot of power of attorneys will make provisions for this that the agent can gift to children or can gift according to your normal pattern of gifting that you've done historically. If this is something that you would want your power of attorney agent to be able to continue to do when you were incapacitated, then you'd want to have that power within the document as well to ensure that that behavior could continue.
I was just going to add that a lot of times, because Massachusetts has a Massachusetts estate tax exemption of $1 million, a lot of times you'll see people, if they're really ill, they're not doing well, their loved ones will say, oh my goodness, they have 1.1 million, or they're just over that threshold, and there's sometimes a good reason to be making last minute gifts like that to reduce estate taxes. So it is kind of nice to have that power, but like Shawnee said, it's not a fit for everybody, right? If you think your power of attorney we shouldn't be picking them if we think they're going to do the wrong thing. But if you don't want them to be in the position of having to make a decision about making a gift, just based on past experience with the family or beneficiaries, then I'd leave it out. But it is often in there as a power.
Yeah, agreed. Okay. And then signing a power of attorney. I think this is something that a lot of people don't know how you are supposed to properly execute the power of attorney. And this is actually really important. Generally, you should sign the person's name that you're the power of attorney for. So Jane Doe by her power of attorney, and then your name, John Doe. So whenever you're writing it, signing a check, signing anything where you're acting in your capacity as the power of attorney agent, you always sign the other person's name by her power of attorney, and then you sign your name. That's really important so that it's clear anytime that you're signing that you signed under power of attorney. You don't want to sign just their name or just your name. You do want to sign this whole long thing, and I know it can be a little bit of a pain because it's long, but that's definitely the recommended way to sign documents when you're acting under power of attorney. Because you don't want to sign individually, especially if you're doing these sort of nursing home applications, which is a common use of the power of attorney. You have a loved one, you may be a parent or something that's going into a nursing home, and you've got to fill out all this information. You want to make sure that you're not signing anything that's gonna individually that's making you financially obligated to make payments to the nursing home for your parent. And a lot of the forms when you're doing the nursing home applications, even when they're all a little bit different, but sometimes even when I read them, they like word them like really trickily. So it's like you really want to be careful and make sure you just sign everything under power of attorney or anything. Like you don't want to ever obligate yourself or put yourself at risk. So it's really important that when you're doing stuff, it's clear that you're signing under power of attorney and not in an individual capacity. So there's no argument that you are obligated to the nursing home or any other institution in any way.
We had a couple cases a couple years ago where, and like you said, Shawnee, it's like you're reading these forms, the nursing home packet and what you're required to sign, and sometimes it's hard even for us to understand. And I'm pretty sure that sometimes the person presenting you this contract doesn't understand the legal implications of it. But the issue that arose in the two cases we had a couple years ago was that the nursing home form said, oh, Mr. Power of Attorney, you're signing this form as you. And we said, we don't want our client to do that. And they said, no, you're only saying that you're going to use the applicant, the person going into the nursing home's assets for care. So you're not putting yourself on the hook. But what has happened in the past is, say the applicant's applying for Mass Health or Medicaid benefits, and while they're in the nursing home, they apply for benefits, they pass away before they get benefits. There have been cases in Massachusetts where the power, because the nursing home benefits can sometimes be retroactive. If the power of attorney abandoned the application, person passes away and didn't take steps to see through the retroactive applicability of the potential benefits, now they're saying, well, you said you were going to do everything you could to use their resources and you didn't, and now you're personally on the hook. So it can sometimes be kind of sneaky. So we really caution people to be very careful about, if you're acting as power of attorney and you're signing on behalf of the agent, you're signing their name. It should not be you, and you should always question if someone's making you sign as an individual. That's why we wrote on the side, like, just consult with an attorney, because it's something we can look at for you and help you interpret what they're asking you to sign.
Yeah, Yeah, and I think that's true, that a lot of times the person, the admissions person or whatever at the nursing home, they have no idea, like their legal
Right.
department gave them this
They have a
application and said,
checklist.
yeah, this is what you're supposed to do. So they're not always like coming from some sneaky place that they're trying to trick you. They
Right.
don't know either. They're not attorneys. They're just, you know, like trying to do their job. They have no idea. So
Yeah, it's right. So I totally agree. Sometimes not even
Yeah.
intentional. It just happens.
yeah, yeah.
So how do you protect yourself? Because hopefully what you're picking up on already is that serving as a fiduciary, serving as a power of attorney for someone else is a very serious role. And like I said at the very beginning of the presentation, is what we find in practice is that folks are already, we see a lot in the parent-child relationship, the kids are already helping mom and dad with so much, and it just kind of creeps up the level of involvement over time, and next thing you know you're writing checks and helping with bills, and you really are managing their assets, but there was no formal switch in your mind of, wait a minute, I'm power of attorney, I should really be formalizing what I'm doing here. So the first thing I always encourage people to do is just appreciate that in your mind. You are managing somebody else's assets, and the more kind of removed from the relationship you can get yourself mentally, meaning, oh, I'm not just stopping by and helping mom and dad with this. Try to think of it as almost a third party that you were hired to help. And I'm not saying be impersonal, because obviously you want to give all the same love and affection as you would have before, but what I'm saying is appreciate the fact that you are in fact managing somebody's assets. And if you start to think of it like a third person, maybe a more distant relative even, you will start to appreciate why it would be important to keep track of what you do, keep spreadsheets. You never want to commingle your assets. So this is a mistake we see a lot of people make. So they have mom or dad's credit card and they're serving as power of attorney. And one day on their way home from work, they pick up groceries and they grab a bunch of stuff for mom and dad, drop it off at the house. Next day, go to the gas station and they're like, oh, well, I spent all that money buying mom groceries, so I'll put my gas on their credit card. And it might not be an unethical thing to have done because it evened out, but that is a commingling of assets. You can't do that. You're now, it's not clear anymore what's your assets and what's their assets. And if someone is ever trying to accuse you of having done the wrong thing, which guess what, siblings do to each other all the time, they're looking for those things. And while you can maybe tie out every single one of them, it paints you in the light of being a bad fiduciary and having not done as good of a job as you could have. Always consider also consolidating the assets of the principal, the person who set up the power of attorney, because if you're going to try to keep things very clear, keep good records, it's a heck of a lot easier if you've got one bank account, one investment account. Because say you are ever asked to produce those records, you're going to have to show statements for the time period that you were serving as power of attorney. And if you have to grab those from multiple entities, sometimes you have to pay for them, and it can just turn into a huge hassle. And then you just have less transactions to worry about, because if you start moving money from this account to this account to that account, it can get much harder to produce an accounting of what you did. And what I find is when most people, and maybe I've just been blessed to have really wonderful clients, but most people are not doing the wrong thing. Like they're not trying to be inappropriate with funds. It's mostly just sloppy record keeping. So when you are the child or the relative that took care of your loved one, and it's hard, right? You're up against taking care of your own family and your own work and all of what you've got, and now you're layering on this responsibility. And then you've got, because this is a traditional situation we see, all the other siblings don't do anything, you are saddled with all the work, and then mom or dad passes, and now all of a sudden everybody wants to know what you did during that whole time period. That is really, really emotionally trying on our clients. It's really difficult to go through. So that's why we really urge people to try to simplify and consolidate if you're at that point where you're having to take over as someone's power of attorney. Right from the get-go, if you take over as someone's power of attorney and you're now serving in this capacity, you want to take an inventory of what they own, because like Shawnee pointed out, some people have trusts set up. And if they have assets in the trust and you're not the trustee, then you're not in charge of those assets. You're only going to be in charge of the assets outside of the trust. This is a common mistake we see people make, is they kind of assume that, oh, I'm power of attorney, and they've got this kind of like very superficial understanding of what that means, and they're not appreciating that it's a contract. This person that set up the power of attorney listed for you powers that you have. You do not just have every power that you think a power of attorney should have. And we hear this from clients all the time. Well, can I just sign it because I'm power of attorney, or can I just do it? No, we got to look at the document, and does it permit this particular action? And that document is your guiding document. It has to be in there in order for you to be able to take that action. But beyond just the scope of the document, it is important to understand the person that set up the power of attorney. We want to understand what were their estate planning goals, and what's the big picture look like here, because there might be proactive actions you should be taking. For instance, here I put like if there was elder abuse, are there potentially funds that have been stolen? You're really stepping into the shoes of the person for whom you're acting as power of attorney. So if it's something that they really should be doing for themselves to protect themselves and protect their assets, you should be doing that. So consider kind of the broader scope of what might be falling on your lap in terms of responsibility, that you're not just reactively taking care of paying bills and things like that. And that's a great reason to have a consultation with an attorney. It's just, for $400 an hour, $300 an hour, you could sit with an attorney and just run through the facts of your particular case, show them the document, and just get some tips and tricks to make sure that you're doing it properly. I think that's money well spent. Keeping track of who has the power of attorney is, again, something we see people fail to do all the time. And that's because you're caught up in the moment of, oh, I needed to sign this with this bank or update the mortgage company, whatever. You're task by task using the power of attorney. Well, what happens if someone resigns as power of attorney, or the power of attorney themselves becomes incapacitated, and now you're faced with having to make sure that person is no longer acting? Or what if you, as the person that set up your power of attorney, now don't trust the person you named as power of attorney? If this document has been provided to third parties, they have that on file, they can still rely on that. So they have no way to know that it was revoked. So if your first power of attorney shows up at the bank trying to do some kind of fishy, and you are saying, well, I removed them, why on earth is the bank letting them do this? The bank has no knowledge of that person being removed as power of attorney unless we've provided all of the third parties that have a copy of that power of attorney with the updated one, or the resignation or removal of the current acting power of attorney. If you have no idea where copies of it are, go asset by asset, institution by institution, and just provide a new copy and just say, hey, I don't know what you have on file. This is the most common one. So somebody's financial advisor, any financial institution where they have assets, that would be kind of a good clean sweep, just to make sure you have provided the most current one. If you yourself are power of attorney and you suspect that there's been a revocation, meaning either the person that set up the power of attorney has decided to change it, you don't enjoy that same protection that the third parties do. So third parties that are saying, oh, hey, here's the power of attorney that we have on file. And, oh, that's you, perfect, you can do what it says here. If you are the person acting as the fiduciary and you believe that there could be a reason that you were removed, you cannot continue to act. You really should not continue to act, because any action you take outside of the scope of your power in the power of attorney document puts you at risk personally. So mishandling of funds, misappropriation of funds, things like that. You don't want to be subject to those claims. This, I think, is probably the most important slide in this whole slide deck, and basically the crux of the reason I do this presentation is because people don't understand this. The burden of proof shifts when you are serving as somebody's power of attorney. So in a standard lawsuit, if I allege, say I am suing Shawnee because I think she did something wrong, it is my job to prove that Shawnee did something wrong. Same thing in criminal law. We see that where, state files charges against a criminal, they have to prove that the criminal committed the crime beyond a reasonable doubt. That's called a standard of proof. And that's typically how it works. If I sue Shawnee and I say, hey, I think you did the wrong thing as that person's power of attorney, and this is true of other fiduciary roles as well. So if Shawnee is serving as somebody's fiduciary and I say, hey, you did the wrong thing, now I don't have the burden of proof. I don't have to prove that she did the wrong thing. She has to produce evidence to show that she did the right thing. So she has to show that her actions were proper. So this is the number one reason why it's so critical and important to keep spreadsheets and keep track of what you did, notes about, major decisions you made, things that can build your case if somebody challenges you having done the wrong thing. And we see this all the time where it's, one kid, two kids taking care of mom and dad, and then all the other siblings show up once mom and dad are gone and they're looking for some money and they're saying, well, did they have to be in assisted living that soon, or couldn't you have found somebody to come in for a time period to provide in-home care? Would that be less expensive? And we've had people accuse their siblings of all sorts of different things, and the ones that have kept good records are better protected. And I can tell you, I have seen, we don't do litigation, but we work with litigators a lot when these cases escalate. But I can tell you, I have seen people negotiate and give money to siblings that they despise and did nothing to help because they don't have that evidence, and to face litigation and depositions and just the cost of it can get people settlements. So, and it doesn't cost much for someone to just accuse someone of doing the wrong thing. So it's a little bit scary if you're not keeping good records about what you're doing. So if you're not serving as power of attorney and you're sitting here attending this presentation thinking, okay, I need to have a power of attorney, or I have one, how do I be smart about who I'm picking? And the number one piece of advice I can give you is just pick somebody that's well suited. Don't pick somebody, don't do what a lot of our clients do, which is they come to our office and they're like, well, I mean, so-and-so the healthcare proxy, and I don't want to hurt her feelings, so I'll make her power of attorney. This is not a, name everybody gets a trophy and everyone participates in the estate plan type of decision. You've got to pick somebody that is a taskmaster, good at organization, and somebody that would appreciate the nature of the role and understanding that they're going to be a power of attorney. They've got to be responsible, responsive, trustworthy. They don't have to necessarily be close to you, because I know physical proximity is something a lot of our clients care about. And sure, that can be helpful if you've got local banks and things like that. But you don't have to. It's not absolutely critical. Like nowadays, you can sign things, over digitally and mail things back and forth. It's pretty easy to do a lot of business. Just keep an eye on time. But you can also put in a substitution power. So a lot of our clients will do that, where you can, say you've got particular assets in a particular state, you want the one child to be in charge of those assets, and they could sub someone in for just that particular part of the job. You can do things like that. And then obviously we want people to be naming successors, because while you might pick one person, what if that's a child and the child is 35 and single, but then when it's time to be power of attorney, they've got, 4 kids and are juggling a career, or maybe it's just not a great time for them to serve as power of attorney, and there's another sibling that's better suited, or somebody else is better suited. It would be good for you to have picked who those successors are, so you can give an opportunity for your agent to resign. Other tips, let me make sure I speak about these in the right order if there are. This is a good tip, is if there are things you don't want your power of attorney, because we talked about that, and Shawnee was talking about how we drop them as intentionally very broad, because the point is, if you need to take an action and it's not articulated in the document, you're going to be going through a court process to get permission to take that action. Well, most people are trying to avoid that. So we are trying to go pretty broad in terms of what powers we put into these documents. But this is why you work with an attorney and not LegalZoom online, you need to have a discussion with your attorney about what don't you want your power of attorney to be able to do. So we see this a lot in second marriages, where, okay, you might each want to do certain things with certain assets and then do something differently. Maybe you bought a house together and that's something you share and you want to treat differently than the assets that you came into the marriage with. Maybe those go to children from the first marriage. And that with all the blended families and different situations we see, there are very good reasons why you might not want your power of attorney to be able to self-deal or do make changes to the estate plan, or change beneficiaries of retirement account or life insurance policies. Those are common powers we remove from the power of attorney document in discussions with our clients. And if you have updated over time, this is just a note of caution. A lot of times financial advisors, like the financial institutions, have their own form. So you say, here's my power of attorney. And they're like, oh, okay, we want to supplement it with this form in our system. And they're not usually conflicting. It's usually just meant to jive with their compliance records. But for that reason, if you've updated your power of attorney, just make sure that you are giving it to your financial advisor and being proactive about where you've provided it while you are not even using it. And kind of related is we really encourage clients not to let their power of attorney be older than 5 to 7 years old. And the reason for that is, even though it's not like it goes stale and now it can't be used, you can enforce a power of attorney that is older than that, meaning you can say, okay, Mr. Bank or institution, you have to accept this power of attorney because it was properly executed. The issue is that execution laws might change over time. Powers that have to be or don't have to be articulated in the power of attorney could change over time. So what happens is, if you get a 30-year-old or 20-year-old power of attorney that walks through the door, the teller has no idea what they're looking at. They're kicking it right back to legal to make sure it's okay. And then, or say it was executed in another state, you're going straight to legal. And legal at the bank is like, sometimes, I mean, I've had it where it's, also the teller, and you kind of wonder what the heck's going on. But then Bank of America has all of their legal department in North Carolina. So there are delays that are caused by it being older. So until they review it and approve it, because they don't want to take on any liability, it's a big deal. You say, oh, I'm going to close this account and consolidate it. Well, they don't want to let you do that unless they're sure that you have the authority to do that. So we can appreciate why they're being cautious. But if it's within a few years, then better to have a new one. And what I always like to remind people is better to do it while you don't want, if it's old and it needs to be updated, but there's a cognitive issue, we're going to tell you don't update it, stay with what you have, because you don't want anybody to challenge it as invalid because you didn't understand what you were doing at the time that you updated it. So obviously we never know when someone's going to have a cognitive issue or disability, so we want it updated so that if that is 20, 30 years out, we have at least as new of a document as we could have had. So that is it. This last point is important because we have a lot of clients that are in Florida and Massachusetts and bouncing between states. Different states have different execution requirements. For instance, Florida has the self-dealing provision. You have to initial, there's like 40 initials that you have to place on a Florida power of attorney, which we don't have at all in Massachusetts, but they're very particular about making sure that every single power is gone through with the client. And then there's other states that put a notice on the front of the document that you have to read, and it's in big bold letters. So there are different states that have different requirements. So for that reason, we always say, if you're going to be using your power of attorney in 2 states, let's make sure that it complies very easily, so that when you do get that teller who's just used to seeing it this way, we want them to see that and they recognize it, and it's easily usable in the states that you're in. So we have one question. So let me read that, and then just to let everyone know, if you do have questions, you can go ahead and submit them in the questions section, and we will try to answer them. We have a few more minutes, and if we don't get to all the questions, then we can always email offline. So this is a question. I hold the power of attorney, medical, executive, etc. for my sister. She signed the documents at the very early stages of memory issues. As she's declining when, how should I share this formally with her 3 adult children? They are aware that she did this, but wondering the timeline. So Shawnee, you can weigh in on this too, because it's more of a matter of opinion. It's not really a legal question. Personally, I find that more information early on is better, because if there is, but you always have to weigh this against you knowing the facts and circumstances much more than I do, because I look at it as, if there's going to be a conflict and there's going to be an issue, it's better for them to know. And then, mom could so while she's still able to tell them why she made this decision and help them understand. But you have to weigh that against, if you feel like, geez, these kids are going to be all over her and pressuring her and putting her in a really uncomfortable position to try to change it, then I'd probably wait till later. You have any thoughts on that, Shawnee?
Yeah, I agree. I'm also like big on letting your family know why you've made certain decisions, as far as like picking people or even like with inheritance, to like talk about it now, because a lot of times that can help with there being any problems after the fact. If they, if you talk about it and you can let them know why you picked your sister as the power of attorney agent as opposed to your kid, then then the kids can hear that and it's like, oh yeah, okay, I understand, that makes sense, as opposed to like you said, after mom's no longer able to explain herself or why she did that, then it can cause tension. So I'm big on information and everybody sort of like being on the same page. But certain circumstances, maybe it doesn't make sense to do that, but that's always sort of like my go-to as well.
And we have another question about, and this is a really great point, is this person is asking about, okay, I'm power of attorney for my sister. She's got a checking account in another state and her daughter is a joint owner. So when I talked about taking an inventory of the assets, I don't think I mentioned this, but this is really important, is you've got to see if they own assets with somebody else, because what happens by operational law with the joint account is the surviving owner has access to those funds, and your power of attorney has expired because your sister passed away. You're no longer able to act as power of attorney. If you're named as executor or personal representative in the will, you might be able to then open an estate and try to access those funds. But the question becomes, when mom made daughter an owner on the account, was that an intended gift? Because functionally what happens is the surviving owner has access to the account and is now the sole owner. So it can be a gift. It could be, and we see people do this, where you put one child on each account, which we do not advise to do. It's not a great idea. If there's cost of administration, you're going to need access to those funds. And if you just gave them away, not a great move, which could be the case here, where she's saying, hey, I might need to get into that account. There is what's called the ability to add somebody onto an account for convenience purposes only. And sometimes if you pull the bank forms from when they added the person, they will have checked that off, but it's not always a question on the form. So sometimes it's really hard to tell. And you do end up in this fight with the child saying, hey, I really need those funds to pay for X, Y, Z. And this could be a really hostile move, but if you assess the situation and determine that you're really going to need those funds to pay for mom's expenses, and you're worried that daughter is going to either take the money or after mom passes just try to act like it's a gift, and you don't want to have to sue her later to sort that out, you could review the power of attorney to see if it authorizes you to remove the joint owner, because as power of attorney, you can act as your sister to access that account just like she could. The only difference is now that account that would have bypassed the probate court system by having passed automatically to the daughter will pass through the probate court process. But you have to assess the situation and determine what's going to be best overall. But the answer is that the funds do go to the daughter. All right, so it's 9:20. We don't have any other questions. We have one more presentation in our summer education series. It's on Tuesday, August 31st at 8:30, and it will be a new face, attorney Emily Esch, who I don't think has She might have been on the first one in the series, but I don't think you guys have met her. She's a newer attorney at the firm. She handles a lot of probate and estate settlement cases. So she's going to be talking about avoiding probate and simplifying probate if you can avoid it, or choosing not to avoid it. So that will be really helpful because she is certainly boots on the ground with a lot of clients going through this process on the settlement side of things. So thank you everyone for joining us this morning, and we hope to see you at our last presentation. Take care, everyone. Thank you.
Bye.
Bye.